And I have your bio up and already. And let's see, okay, so we have naming people as we go.
Ms. Pierre, if you want my opinion, I prefer Reverend Jones. That's when I'm not in court, that's pretty much the way I'm referred to if you want my view.
Okay, yes, that is what I was asking for. So, and with me, it's Mary Lynn, in case you were wondering.
Okay, all right.
Paul, I think whenever you're ready.
Great, because we like to start on time here at You Be the Judge. So at 6 o'clock every Wednesday at 6 p.m., we come to you, Marilyn, Judge Claudia Barber, and I, and Dr. Paul Dyer. We like to come to you, You Be the Judge, every Wednesday at 6 p.m. We have a special guest, but more importantly, you hold your questions till after we discuss with our guest and what's going on. And a lot of times people get misunderstood. So a lot of this information, please understand information, understand your thoughts and your perspective, but listen to the facts. This is the key thing. There are facts that are always involved in the case, not your perception and not your emotional concepts. So with that being said, I'd like to introduce my two beautiful co-hosts that I'm so lucky to be behind. It is Judge Claudia Barbara and Marilyn Pierre, who's soon to become Circuit Court Judge of Montgomery County. And I'll say this over and over as you guys as you guys listen to this. You can always listen to this on iHeart and iTunes Radio and wherever you get your podcasts. Go on Bridges Live, You Be the Judge, and you would find us. But again, send money. Marilyn needs money to win, and that's just a fact, and that's not a perception. So, Marilyn, please take it away.
Well, thank you very much for that. I really appreciate the boost that you give me every week. I think that I'm going to hopefully reserve 5 minutes at the end of this meeting so we could talk about Haiti. A lot of people have been asking me about it, so just fair warning. In the meantime, I would like to let Judge Barber introduce herself before I read the Reverend the Reverend Rickey Nelson Jones's bio.
Well, welcome everyone. I'm former Administrative Law Judge Claudia Barber, and I am just excited for this program because the guest and you, co-host Mary Lynn Pierre, and I have something in common. All three of us have been judicial candidates running for election. So it's going to be an exciting program.
Well, I think so too. So let me get started. I'm sharing the screen because Reverend Nelson's bio is just so long and it's just so it's filled with so many things. I wanted to share the screen with you so you could read along with me. Okay, so we could start. Reverend Rickey Nelson Jones.
Mm-hmm.
I'm sorry, did you say something, Dr. Dyer?
No.
Oh, Judge Barber, you were on mute when you were speaking, so I didn't hear you.
Okay, I was saying that you identified him as Reverend Nelson, and he's actually Reverend Jones, or Rickey Nelson Jones.
I am so sorry. I don't know why I'm having such difficulty with your name, Reverend Jones, because, I speak with you. I've spoken with you many times before, and so today I'm just, okay, sorry. Okay, thank you very much for that, Judge Barber. See, that's another reason why I'm sharing screen, because people could see it for themselves. Okay. Reverend Rickey Nelson Jones, Esquire, is a 1985 graduate of Loyola University in New Orleans with 2 bachelor's degrees in English and political science. He was one of 21 students at the university to receive special recognition for academic excellence during his matriculation. Reverend Jones graduated from Howard University School of Law in 1988 in the top half of his class with a doctorate degree in jurisprudence, serving as class vice president. And I have to stop right there and say, go Bison, woo! Reverend Jones worked for the federal government and a law firm before commencing his exclusive, diverse, multi-state law practice devoted principally to churches and church members. For over 36 years, he has been involved with the education and practice of law, doing civil law, criminal law, administrative law, and appellate law around the country and in state and federal court, covering 16 different substantive areas of law. I told you that this man was very impressive. Reverend Jones has written several legal articles which have been published by the American Bar Association and the National Bar Association. He has also served as a continuing legal education panelist 11 times at 11 different bar conferences. Reverend Jones is presently, and I need to take a deep breath because there's so much. Reverend Jones is presently one, the second vice president of the NAACP and Arundel County, Maryland chapter, the chair of the Criminal Justice Committee of the NAACP and Arundel, Maryland chapter, the spiritual advisor and co-chair of the Judicial Committee for the Caucuses of African American Leaders in Annapolis, Maryland, and the chair of the National Bar Association's Law and Religion section. Reverend Jones is the life member of the National Bar Association and honorary member of the National Black Lawyers Top 100 and the recipient of numerous state and local awards and citations for his professional accomplishment. Reverend Jones is catechized, and I had to look up that word to make sure I pronounced it properly. That's why you see the pronunciation in there. Reverend Jones is catechized, privately educated, licensed, ordained, let me restate that again. Reverend Jones is a catechized, privately educated, licensed, ordained Baptist minister and pastor of nearly 20 years. He has written 2 published books on the Bible. Reverend Jones lives in Anne Arundel County with his wife of over 35 years. They have one who is a graduate of the University of Maryland, College Park, with a Bachelor of Science degree in Animal Science. He presently works in his field of study with the federal government. He also serves faithfully with his father and mother in their ministry, living exactly like Jesus Baptist Church. Ladies and gentlemen, it is my pleasure to welcome Reverend Jones to our podcast today.
Thank you very much, Mary Lynn. I appreciate that very much. What I want to share is, because I was just interviewed by the Judicial Nominating Commission, and when I went there, I had in mind to share with them the history of the commission. Many of them are on that commission. They've never been on there before, and they have no idea about the history of what the commission has been doing. So what I want to do is, I had one of my assistants to do some research on all of the attorneys who've been recommended to the governor and put on the bench on the circuit court for Anne Arundel County. And I wanted the commission to know what it has been doing. So what I want to do is I want to share this research I had one of my assistants to do. I want to share with you my conclusions from that research, and then we can discuss some other things in terms of the need for a class action lawsuit and why without that, these folk ain't thinking about changing. So let me share with you some of the facts from my assistant here that she did this research for me about the Judicial Nominating Commission for Anne Arundel County. And I also shared these facts in my interview with the members of the Judicial Nominating Commission. And they all, at least all the Caucasians, put their heads down in shame because this is outrageous. So I'm going to share these facts first. Number one, the majority of those recommended and appointed to the bench focus principally on criminal law in the Attorney General's office. 2, the next area of law in which most served was the Public Defender's Office, again focusing on criminal law. 3, the third area was in law firms of private practice doing the following: family law, personal injury, business law, DUI, DWI, traffic law, mediation, and appeals. That's it. The 4th area was lawyer positions with city, county, and state governments. And the 5th area, these are the ones that they recommend to the governor will put on the bench. A few of them served as clerks for judges, professorships in law schools, and attorneys for the federal government. This is all that they have been putting on the bench. Now, here's some conclusions from this data. The maximum number of legal areas practiced in at any one time was about 6. And the practice of law was confined to the state of Maryland with rare exceptions. They did not have a diverse practicing law in other states like Reverend Jones. Everything principally was confined to Maryland. The commission also recommended people to the governor who had, they showed a preference for recommending former state's attorneys, those primarily focusing on criminal law alone. 3, the commission also showed a preference for recommending Caucasians, even when they were not the most objectively qualified in terms of legal knowledge, experience, and scholarship. In Anne Arundel County on the circuit court, they have excluded non-Caucasians from the bench at 99.97%. You may be able to say 91% now because they recently put Judge Morris up there, but Judge Morris didn't get appointed until members of the NAACP like me, Judge Barber, and some other members held signs and protested in front of the circuit court for Anne Arundel County, the heart of our capital, Annapolis. We on the streets with signs protesting. Judge Morris was not out there. She's the beneficiary of our labor. Next, the commission has shown a preference for those heavily involved in bar associations and organizations. This is what is happening. Not black folk, not Asian people, not mixed people. I'm talking about people of mixed race, black and white, not Pacific Islanders. 99.97% of the people that have been put on the circuit court for Anne Arundel County has been Caucasians. Anne Arundel County is approximately 40% non-Caucasian. So what we have in front of us is really taxation without representation, because we're supporting these circuit courts with our tax money. And so I'm going to talk about that a little bit later, because the class action lawsuit, at least my office, is not only thinking about the discrimination, but there's some constitutional issues here. Because when you're using tax money for any arbitrary or unreasonable purpose, that's a violation of substantive due process. So my law office is kind of thinking about attacking this in various fashions in a class action lawsuit. Here's some conclusions. This commission's profile, this is the profile of who they put on the bench. Caucasian folk confined to Maryland, no more than about 6 areas of the law that they practice in, and do not have the rich scholastic experience in terms of writing about the law and having the articles published nationwide, serving as a panelist on continuing legal education classes at bar associations at least 10 times. None of those qualifications. So basically, a Caucasian person practicing law in Maryland with maybe no more than about 5 areas of the law. That's their profile. This commission's profile has been limited, and the limitation is excluded those practicing in numerous areas of the law, those practicing both state and federal court, those practicing law in more than one state, and those who have written and presented on law extensively, and those who are not Caucasians. The limitation has basically kept these folk out. I'm talking about the history of the Judicial Nominating Commission. It came into existence in 1970. That's when it was put into existence legally. And the entire history for Anne Arundel County has had a limited profile of basically white folk with limited legal education and knowledge. In short, the Judicial Nominating Commission for Anne Arundel County has, as a normal and continuing historical practice, presented to the governor Caucasians who are less qualified in terms of legal knowledge than Reverend Jones. They do not practice in 16 areas. Less qualified in terms of legal experience than Reverend Jones. If you do not practice and thoroughly review the law, for example, in 16 areas, don't tell me because you're reviewing the law in 4 areas that you're more qualified and more knowledgeable about the law than Reverend Jones. That's nonsense. Less qualified in terms of legal scholarship than Reverend Jones. If they have not written legal articles that have been published nationwide and subject to scrutiny to make sure it was legally sound, if they have not served as a continuing legal education panelist, you can't think that they have.
Why do you think they're doing this?
Well, obviously, it is the delusion of superiority. And what's happening in the judicial system is, when you have a delusion of superiority, you're constantly looking to do things to give some legitimacy to that delusion. And so what we have a lot of Caucasians who are suffering from the delusion of superiority, and we see it reflected throughout our society. And even in the judiciary, where people come to get justice and fairness, is saturating the judiciary. So this is the reason why it exists, is because of the delusion of superiority that many white folks suffer from. Next.
So you have testified before the state legislature. Why?
because there's a need to basically come up with legislation to revamp this entire Judicial Nominating Commission process. When I shared these facts at my interview about a month ago, all the Caucasians put their heads down in shame. But the point that I want to emphasize is that this has been going on from its inception. So this is not about shame or feelings. This is about a need for a complete revamping and trashing of this discriminatory, racially exclusionary system that exists. I don't want everybody to miss this either. The circuit court has the most influence over our lives. Serious criminal matters, major civil matters, family law, juvenile law, appeals from a district court, the orphans court, appeals from administrative agencies. If you start thinking about that, that's basically everything that affects our lives. So it's not so much that we don't see this in the district court, it's the circuit court that has a major hand in our lives. So by keeping this race exclusionary thing in place for the circuit court, it is a way of pushing and supporting this delusion of superiority and keeping other folk who are more qualified for being on the bench to administer what is just, fair, and righteous for all people without regard to race, ethnicity, creed, color, these type things. What we have a
solutions. What solutions do you have to offer?
I have a couple solutions. Let me get to that in a minute. Yeah, let me get to that in a minute. What we have occurring, legally speaking, is disparate impact discrimination. When a practice excludes protected members of our civil rights laws, the United States Supreme Court authorizes use of statistical proof to show discrimination. In Anne Arundel County, Maryland, because non-Caucasians have been excluded from the court at over 99%, the better objective qualifications have been tossed aside. In fact, and this is important because sometimes people say, well, they consider some other things, they consider some subjective things. Let me say this. Objectively, if you toss that aside in fact, and then you put a Caucasian on the bench who is not as objectively qualified and claim that you did it subjectively, subjectivity is the lifeblood of discrimination. Subjectivity is the lifeblood of discrimination. If a non-Caucasian was not objectively qualified, we wouldn't even get to any subjectivity. But it only seems to be when a Caucasian is less objectively qualified that they run to subjectivity because it's the lifeblood of discrimination. The Judicial Nominating Commission in Anne Arundel County has and continues to foster a discriminatory, unlawful practice. It is filling the circuit courts with less objectively qualified Caucasians claiming they have been vetted, but remain silent about the vetting process, abandoning the most objectively qualified. What happens is they have a love of manipulating the public. When you see a Caucasian on the bench and some African American who's practicing 16 areas and this Caucasian practicing in 2 areas, and I've been practicing involved in the law for 36 years, they've just been involved with the law for 10 years. When you have that gross objective difference, you will hear them say, well, we put this Caucasian up there and they were vetted. But they would never tell you about what the vetting process consisted of. They want the public to assume they were vetted objectively. And it is that misleading that is the heart of this Jim Crow practice in the judicial nominating and appointment process. It is that. So if you don't have a way to mislead the public, there will be an outrage. How in the world can you have a Reverend Jones and somebody else from our community practicing law for 30 years and you put a Caucasian on the bench who's been in private practice for 1.5 years, and I've been in private practice for 30 years. These are the type of facts that exist that we never really hear about. We just hear they were vetted, broad statements like that. Now,
is it fair to say that the Judicial Nominating Commission process is a relic of Jim Crow, or that's too much?
No, it is not too much to say that. As a matter of fact, I maintain not just the Judicial Nominating Commission process, but the entire appointment process as far as the circuit court is concerned. You see, with the exception of Baltimore City and PG County, I encourage everybody on the sound of my voice to look at these stats like I looked at in your county, and you will find similar figures. And so we have to realize that this is a Maryland problem, with the exception of PG County and Baltimore City. This is a Maryland problem of this type of Jim Crow, keep white folk on the bench. I don't care how qualified or not qualified they are. It's insidious, it's wicked, and it is an attempt to undergird the delusion of superiority that many white folks suffer from. And so I want to share this proposal, some things that I've been thinking about, that I've been praying about, because I've talked to delegates and senators, and the type of response that we've received is them coming forward with bills to eliminate contempt.
I'm sorry, you're going into the solutions, but before you go into the solutions, I think that we've lost some people. Some people haven't along with us because they have no idea what we're talking about. We know what we're talking about, but there's some people over here who have no idea what the process is on how to become a judge in the state of Maryland. And so if you could start from that process and then explain that, it would make more sense when you talk about the solutions.
Yes, absolutely. Okay. Excuse me. The qualifications, you have to be a citizen, of course. You have to have been practicing law at least 5 years. That's kind of the heart of it right there. So if you've been practicing law 5 years, you're a citizen.
Well, it's kind of interesting because I wrote a letter to the administrative office of the court, I think last year, because I always thought you needed to practice law for 5 years, but the interpretation was you need to be a resident of the state of Maryland for 5 years, but you just need to be licensed to practice law in Maryland, which was really kind of interesting to me because I said, wait a second, let me get this right. A judge could just be somebody who got their license yesterday, and they're like, yeah, that's basically what the conclusion was, and I was surprised myself.
Yeah, one of the things I would say is that usually, at least the regulation is you got to be a resident, because there's some people who are not attorneys who got on the bench. So that's okay, but when it comes time to evaluating people in terms of qualifications, you can be about 99% certain you're not getting through the Judicial Nominating Commission process unless they're white and they have a lot of friends or something along those lines. And so basically, I guess the point is to be considered a qualified person to be recommended to the governor. You want to have connections. Yeah, you want to have connections. Yeah, but
we have to spell it out and say it like it is. People who generally are shortlisted are people with connections. Not always, 100% of the time, but many times they are connected. They know the governor.
Okay,
they like the governor. The governor likes them. Come on.
Sorry. I'm sharing screens again because I could never remember what the qualifications are at the top of my head. So qualifications of a judge in the state of Maryland. The qualifications of a judge fall into two quite distinct categories. One, legal, and two, professional and personal. The Constitution of Maryland specifies those in the first category, Article 1, Section 12, Article 4, Section 2. The legal qualifications for appointed judges are: 1, United States and Maryland citizenship; 2, registration to vote in state elections at the time of appointment; 3, residence in the state for at least 5 years; 4, residence for at least 6 months next preceding appointment in the geographic area where the vacancy exists; 5, age of at least 30 at the time of appointment; 6, membership in the Maryland bar. The Constitution also speaks generally of the second category of qualifications by providing those selected for judgeships should be lawyers, quote, most distinguished for integrity, wisdom, and sound legal knowledge. Yeah, so anyway, so that's why I called last year, because the third qualification, residence in the state of Maryland, and the sixth qualification, membership in the Maryland bar, those were always confusing to me because I thought you needed to have at least 5 years of bar membership to become a judge, but you could see that they're distinct. All you need is membership.
You know what? That tells you a lot about how this law was drafted. And I believe it was intentionally done so to keep a certain population of people who are connected in the eligibility category.
Exactly. And what Reverend Jones is speaking about, I mean, the legal qualifications, you either have them or you don't. That's just, you basically check a box. So those are the objective qualifications.
Well, now
and
let me
what
add
Reverend
something.
Jones is speaking about, is the subjective qualifications, the so-called professional and personal qualifications.
Let me add this point to your purpose in running. Whenever anybody approaches you at the polls and tell you about qualifications and that the sitting judges are the best qualified, don't believe that rhetoric. Do not believe that rhetoric. Okay? Just like you should never believe the rhetoric that all men are created equal. Just don't believe the rhetoric. It's just rhetoric. Okay? Just like you have in the Constitution that all men are created equal. Maybe they are created equal, but it doesn't mean that society treats everybody equally. It doesn't mean that there's an even application of the law. So, the fact that you have people that are not as qualified as others, that are shortlisted and get to the governor's appointment process to the point that they're appointed, doesn't mean that they're the best qualified, even though the executive order is written that way. Those are just words on paper, just like all men are created equal. So when you go to the polls, you go to the polls with your eyes wide open. You go to the polls and you recognize the fact that Mary Lynn Pierre, does she fit those qualifications exactly as you saw on that screen?
If I may, Mary Lynn, proceed here concerning if the people understand the basic qualifications there, I guess what I'm focusing on is when we have eminently qualified non-Caucasians who are 10 times beyond the basic qualifications, and they are not even recommended to the governor, but Caucasians who are nowhere near, not even in the same house in terms of objective qualifications, are recommended to the governor and put on the bench. And on the bench today, we have a Jim Crow practice in place.
And I'm so sorry to keep interrupting you, but we're here to educate and empower people. And part of it is meeting them where they are at. And some people are not where we are at. So let's go back a little bit. When you say they, I want people to know that it's the Judicial Nominating Commission and what
Trial Court Judicial Nominating Commission.
Yes, Trial Court's Judicial Nominating Commission, and in Anne Arundel County. Well, let me share again. In Anne Arundel County, and I think in most of the counties in Maryland, most of the larger counties anyway, you have 13 members, and those 13 members basically are supposed to interview qualified candidates, the candidates who meet the objective qualifications.
The regulation actually says that they're supposed to evaluate people on the basis of the most professionally and legally qualified. That's the language, professionally and legally qualified. So that's objective. That is not subjective, professionally and legally qualified.
I want to acknowledge Mithen's hand, though, because we do want to get to some questions.
Yes, we do. Which is why I'm thinking, Mithen, I'm so sorry. If you could just hold on just 1 second. So basically what happens is that the governor appoints these people for each county. And the commissioners are supposed to look at the applicants for judicial vacancies and decide who is the most qualified and send a name of who they think subjectively is the most qualified to the governor. And then the governor is supposed to appoint these people. And I think the issue with that we're discussing is that the commission members don't appoint the most qualified because of the subjectiveness that they put on it. So
because of the subjective nature of the process too. Okay. So there are easy cures for this. You can just like you have blind auditions, you can have blind interviews. And secondly, They should stop pretending that when you have one or two black people on a virtually almost all white commission, that you're going to get equity or you're going to get a fair vote. So
and I want you to hold on right there, because I want to go to Mithun, and then after that, I want to go to Reverend Nelson, because I think now that we all understand what the process is and what the commission does, now we could talk about solutions as soon as Mithun is done. Okay, Mithun, your turn.
Okay, thank you very much, thank you, Marilyn, and thank you, Judge. So I just wanted to congratulate Reverend Jones for doing what you are doing for the community, okay? And I wanted to say, I'm not an attorney, but I'm happy to help with you. And it is official in the public record. I have filed a lawsuit against Governor of Maryland as well as County Executive for me getting assaulted in my own house. And I have the video. It's already official. And also, I have a writ of certiorari in the Supreme Court against a defendant where some sitting circuit court judges, now it is in public record now because Supreme Court is public record. So I'm going to release the name of the judges who are, I have evidences that they have collected money as a campaign contribution from the defense attorney's law firm. And one of the judge was his cousin. And these judges never disclosed that to me. They just heard my case, and the admin judge from Circuit Court of Montgomery County had an ex parte communication from the defense attorney's law firm's principal. And when I filed the writ of cert to the certiorari, to the Court of Appeal, I didn't know that. But the chief judge of Maryland Court of Appeal and his husband may have received financial donations where the chief judge never disclosed that. And I wanted an order for getting the order from where the evidence existed, and the chief judge never gave that. Then I have to file a motion for recusal of the chief judge, and they denied my motion. And I had evidence from the Maryland election contribution website who is that. Then the chief judge recused herself. But they made a ruling in my case where they never disclosed the financial transactions between the defense attorney's law firm and the judges. And I am so appalled. Forget about the financial contribution. Judge McAuliffe is a cousin of Steve McAuliffe, who is his campaign manager. And this Judge McAuliffe, he ruled on my case. He never disclosed that his cousin is the principal of the law firm, and he's collecting money from that. And I even filed a motion a day before for recusal, and he threatened me if I file motion, he's going to bar me for filing any more cases. So he forced me to withdraw the motion for recusal. And Judge Fogelman also collected money from Steve McAuliffe. He's a campaign manager, and he never disclosed that. And he did his filing in June. Judge Greenberg, admin judge, had ex parte communication where I was not on the call. What did he talk? Did he ask for campaign finance, donation from them? I don't know. Then another judge, I'll just give you the name, Sharon Burrell, she is the ex-colleague of Steve McAuliffe. I had no idea. I'm not an attorney, and this is a quid pro quo. I even filed complaints to the Judicial Disability Commission. They didn't do anything. I even filed a lawsuit against these judges in federal court. Federal judges dismisses these corruption charges based on judicial immunity.
Mitchum, hold on for a second. And I want the three to answer this individually. He has asked and said this several times. When there is favoritism, is it hard to prove, or can you prove it, and where does it go if you can? And we'll start with you, Ricky.
But the first thing, when you have any type of unethical behavior, you want to start off with, you got to file a motion to recuse. That's the first thing. Second thing you have to do is you have to report them to the Judicial Disabilities Commission, and you got to get that process started. If there's some clear unethical behavior and the judge refuses to recuse himself, that's something that has to be part of the appeal. When we have something that's indisputable, you on appellate court to pull this out and also provide you a copy of what you've been doing in terms of the Commission on Judicial Disabilities. It seemed to be very difficult for them to toss that aside and not deal with that. So my advice is the first thing you want to do is you want to file a motion to recuse that judge from the case after you have your concrete proof. And simultaneously, you want to file a complaint with the Commission for Judicial Disabilities.
Judge Barber?
That's the way you start up.
I have been down this road in a separate issue in which you're trying to challenge favoritism or unethical conduct by a judge. And it's been as recent as this past year where a judge, well, my client had objected to a pretrial conference judge starting a proceeding before they allowed me in the Zoom room. And it wasn't that I was late, I was on time, but there was a dispute with the clerk of court. And the thing that bothered me the most is the fact that when I brought this to the administrative judge's attention, she did not even bother to take any evidence from my client to get his side of the story, because he was present, I was present, his daughter was present, as well as his wife. And that is just, to me, clear evidence of bias. But when we presented all of this to the Judicial Disabilities Commission, it just fell on deaf ears. So I can't even say that the Judicial Disability Commission get it. They get it right all the time. I can't even vouch for them. I cannot say that they're a credible Judicial Disability Commission. And it's not the first time on the federal side too. When I challenged the fact that there were no African American female magistrate judges appointed, and history has already told us that we've just received our first African American female on the federal district court bench all of these years. History has shown that the system has been such that they are practicing exclusion. And when you go up against these judges and you tell them that, look, you're practicing exclusion, that complaint only went but so far. So I don't even consider the federal Judicial Commission process and the circuit to be credible at all. Zero. I have zero faith in those systems. Some of it is just perfunctory. You put nothing but judges on the federal system, and they're just protecting other judges in their wrongness. That's the most effective way I can describe what I've experienced. It's very similar. So I understand everything Mithun said. Absolutely, I understand. These judges should have been required to disclose their conflicts or perceived conflicts. If they're a cousin, if they were a campaign manager, if they were making contributions, all of that should have been brought to the forefront and on the record. If you have no record of that, you have no information that you even try to disclose this information to the public.
And irony, and judge, irony is that I even filed a motion for recusal, and they threatened me to withdraw it unless they were going to be sanctioning me for even filing any more further lawsuits.
That's terrible. That's terrible.
And
so
that's why
Mary Lynn Pierre and I, and also Judge Vicki Gibson, we're working on a book And we did invite Reverend Rickey Nelson Jones. If he wants to jump on board, he can. We are going to co-author a book that, for the most part, defines from our perspective these outrageous racism in the judiciary. And the book is going to be entitled, Racism in the Judiciary is Real. And it's going to be from the perspective of lawyers and judicial candidates as well.
So, Marilyn,
and judges.
I want to say one more thing here.
Hold on, Mittem, hold on. Marilyn, I know you're not a judge. How do you fight this, and how do you would like to correct this once you become a circuit court judge?
Well, I think first we have to know that there's a problem, and a lot of the public doesn't realize that there is a problem. And sometimes they get into cases, and later on, when they're in front of a judge, they're like, oh my gosh, there's a problem here. What do I do about it? Running for judicial office is difficult because a lot of people who vote have never seen the inside of a courtroom. And the people who have seen the inside of a courtroom, they're not empowered to vote. So you're basically saying to people who don't think that they're ever going to be involved in the judicial process or be in front of a judge or be judged based on the way they look or based on their financial status and things of that sort. You're saying to them, please vote for me so that I could protect the people who actually appear in front of these people. And it's really difficult to do that. But I think it's necessary to educate the public, because just because you're not in that courtroom doesn't mean that your rights are not being affected. It doesn't mean that things are being done in your name that you don't necessarily want them to be done in your name.
Well, Mary Lynn, you raised another excellent point, and that is people have to be aware of the fact that just like they practice exclusion in the judicial nominating process by keeping blacks off the bench, they're doing the same thing in the courtroom today. Everybody needs to know that, and that's the thing that needs to stop. They come with those same biases. They come with that same cultural, unconscious gender bias, unconscious race bias, and you see it manifest itself in the decisions that are written and how they weigh the credibility of witnesses. All of that is relevant.
Can I ask the panel a question? And I mean Ricky and Judge Barbara and Marilyn Pierre Esquire, who's soon to be circuit court judge. And could there be a literally black court and white court? Is that possible under our Constitution? Ricky?
I don't think that I would favor something like that, because it would mean to me that just because you're black, you're likely to be fairer to a black person, and just because you're white, you're likely to be fairer to a white person. And I find that quite problematic. What I mean by that is I think Reverend Jones talked about it a little bit earlier, in the sense that there are black people who are appointed as judges who follow the same agenda as the white judges. So whether you're black or white, if your agenda is to follow whatever whatever the white judges would do, without regards to
second that, Marilyn.
So we need somebody who's not just diverse in terms of color, gender, whatever. We also need somebody who's diverse in terms of thought. And I think that's why Reverend Jones and Floyd Barber and we have had such difficulties, because they know that we not only look different from them, we think different from them. And the idea that there would be diversity of thought is extremely scary to them, especially when they're doing things like Mithun talked about. You shouldn't be able to do things like that. There should be a whistleblower who says, hey, you shouldn't do stuff like that, because it's not just to the people that we serve. And public,
they will
public servants, and they're supposed to serve the public.
Well, see, that's the thing. They have, they can try to rationalize their behavior by saying that, well, we have a commission on judicial disabilities, and, it consists of lawyers and judges, and, we have an executive director that's an investigator to investigate. But see, they're not getting to the root of the bias issue, and they're too timid and to really go up against judges because of their prestige. So it's really often about prestige and connections. So no, they're not going to start an investigation on a judge based on a claim of racism. And that's the low level that they believe that's how they value or don't value racism in the court system. That's part of the problem right there.
And that's a perfect segment, because I told Reverend Jones that we would go back to his solutions once we understood everything. Oh, okay.
I want to finish one thing, 10 seconds. If I take 10 seconds, do anybody in the panel knows what is the percentage of the cases that what you call the Disability Commission, the Judicial Disability Commission takes up? I and Marilyn knows that, because I think me and Marilyn did some research the other day.
I think the statistic is out there.
I know, but do you know how much the percentage? Maybe 1 or 2% cases that the complaints they file, they take up only, like I think last year was 199 or something less than 200. They took 1 or 2 of them. Ms. Marilyn, please confirm if I'm correct.
Yeah, it's on the Maryland Court of Appeals' website. And so if anybody wants us to dig that up and forward it to them, we could do that. We have Mr. Friedman has a question. He's had his hand up.
Okay. Sometime between 1962 and 1966, the administrative agency I worked for, as a result of a Supreme Court decision, said that when you dismiss administratively a charge of, in this case, of unfair labor practices, you must state reasons. Now, a statute which says that if somebody is accused of nepotism or other reason for not being impartial, they must answer the accusation with reasons, in writing with reasons. That might reduce the amount of nepotism a bit. That's the end of my comment.
Well, thank you for that. Now, Reverend Nelson, if you could help us with the solutions that you are proposing.
Yes, I'm going to get to the solutions in 1 second here, but let me just say this for the gentleman who's have these problems. I strongly urge you, sir, to get a lawyer, because when you start filing motions to recuse and start filing complaints with the Commission on Judicial Disabilities, sir, you're going to really need I believe you're going to really need a lawyer. I have been successful one time in filing a complaint with the Commission on Judicial Disabilities, but the way I approached that was from the moment I was in the courtroom and the judge was behaving and speaking in a manner that was outrageous. At that moment she was doing it, I began to write down what she was saying word by word. And so by the time I filed my complaint with the Commission on Judicial Disabilities, I had a quote throughout the complaint. And see, it's very, very difficult to lie with specificity. So specificity is a very powerful thing. And so that was the only way I was ever successful. I've only been successful one time, but when you start talking about filing complaints with the Commission on Judicial Disabilities, you need a lawyer-like approach and details. That's all I want to share with him about that. Now, concerning some solutions to this Jim Crow Judicial Nominating Commission and appointment process that exists in the state of Maryland for the circuit court. Number one, I've already gone the route of filing a lawsuit. So that's not the approach. I filed the lawsuit because I had the statistics, I had the facts, and I was eminently more objectively qualified than all the Caucasian attorneys that they put on the bench to be judges from 2014 to the present. None of them had anything close to my objective qualifications. So I filed the lawsuit. The lawsuit was dismissed. In other words, the judge never took into consideration the statistics, the facts, and my qualifications, superior qualifications. I appealed it. The appellate court supported the dismissal. I went to the Court of Appeals. They would not grant the writ of certiorari. I filed a lawsuit for the United States District Court for the District of Maryland. They upheld the dismissal. I filed a lawsuit with the court. I appealed this to the Court of Appeals for the Fourth Circuit. They upheld the dismissal, and I filed a writ of certiorari with the United States Supreme Court, and they denied my writ. So the individual journey legally does not work. So unless we get together, I'm talking about not just African Americans, but non-Caucasians who have either been excluded from being recommended to the governor or who can see the need to change this Jim Crow racially exclusionary judicial nominating and appointment process, unless we come together and a class action lawsuit, they won't even look at these statistics and the facts, because if they ever did that, there's no way in the world they can conclude this system can stay in place. And so I say that to say that I need, in particular from our community and those who have applied for positions have been denied, do some research on your county. Now, I can tell you now, in Baltimore City and PG County, you're going to find similar statistics. And you have to join Reverend Jones in a class action lawsuit. And that's the only way I can think of right now legally that we can bring any type of possibility of change. These folk suffer from the delusion of superiority. And the court system, the way they set it up, they do that to give legitimacy to something that is illegitimate. And therefore, we're dealing with a human condition. And therefore, if we don't attack it together in a class action lawsuit before the federal courts, and if necessary, the United States Supreme Court, it's highly unlikely anything will ever change. Let me say this. I filed a writ of certiorari before the United States Supreme Court for a client of mine in prison right now. And the United States Supreme Court granted my writ. And I'm in the process now of getting this young man out of jail who's put in jail for just preposterous things. So it's possible, even though it's rare, that the United States Supreme Court will grant a writ of certiorari if the facts and the law and your argument is flawless. We don't need anybody to go down this road individually. I've already done that, spent my own money. You don't need to do that. We got to try a class action lawsuit. That's the first solution. Second solution is somehow we got to reach our legislators. I've tried to do that. And they don't seem to understand the magnitude of this problem. They don't seem to grasp that a circuit court judge can affect your life and your children's life in a way that no other judge in this state can do. And they don't seem to grasp that when you have a racially exclusionary circuit court, you have a system that will be devastating against non-Caucasians and very favorable towards Caucasians. This affects the entire state. Let me say this before we leave here. Systemic racism. I want to give you a definition, give an idea of this. This is a system in which you have policies and practices that saturate society to make sure that Caucasians are benefited by it and non-Caucasians are not benefited or punished by it. It's ingrained in the culture in terms of policies, practices, and procedures. This is what we're looking at in the judiciary. And unless we come together in a class action lawsuit, I do not see anything changing. I had one conversation with a judge in the National Bar Association. I'm an officer there because I wanted to find out what they did in Louisiana, my home state, to get this Jim Crow system trashed and put a stop to this. And she explained to me that one of the things they had to do was they had to come together and get to the legislature and make them create I guess you would call it a region that was predominantly African American. And then African Americans had to run for the judgeships and get the support of that region of predominantly African Americans. And that's how they got judges on the bench. And so this is the reason why you see black judges on the bench in PG County and Baltimore City.
Well, now that you've mentioned that, it is incumbent upon us to remember that there is a gubernatorial election upon us in 2022. And we should take seriously these candidates. If they're not up to the task of appointing judges to the point that there is diversification on the trial court benches, we need to dismiss them and not even consider their candidacy. I just said it. I'm sorry. They need to get serious about it, and they need to get serious about correcting the failures in the Judicial Nominating Commission process.
Don't be
So
sorry.
yes, I said that too.
Yeah, don't be sorry. It was needed to be said, and people need to hear it, and they haven't thought of it. I have thought of it. I'm sure other people have thought of it, but it needs to be said because, believe it or not, like Rickey Nelson said, this is a human condition, and people don't think. People react, and people just do. And I don't want people to react to this type of information. I want you to go do your own research. Do your own research on your own county. Get back to us because your eyes will be open. We have already done ours. You do yours. And if you don't do yours, then you're just another pawn. And that is what they're betting on. That you become the pawn that they push around and nothing that we can use.
I think that Judge Barber.
I just want to share one thing before I'm going to conclude with this. And that is, I think one of the difficulties with our community is, I'm talking about those of us who have been poured into our community. I'm talking about we have multiple degrees, houses, land, money. Our community has poured into us in an extraordinary way. And one of the things that I've discovered, even when I was fighting my own lawsuit against this, is that it's very difficult to get people from our community to get on board in the fight. I believe it may be a combination of fear and thinking that these people are going to blackball you. And what I wanted to say to folk like that, number one, God has not given us a spirit of fear, but of love, power, and a sound mind, 2 Timothy chapter 1, verse 6. And so it can't be afraid because fear will render you incapable of doing that which you're capable of doing. And also, you need not be afraid about being blackballed because we're already blackballed. They're keeping us off the bench. And so you need to get that out of your mind. And this will not change because these folk suffer from the delusion of superiority. Too many white folks suffer from that, and they're not trying to change. They're trying to legitimize it, even though it's illegitimate. Thank you. That's all I wanted to share.
I think that Judge Barber made an excellent suggestion as to a solution for this problem, and that would be a controversial expose that makes the best Times bestseller list, and you would generate conversation, and you would give publicity to these issues. But the book must be entrenched in facts and statistics. And it must be, you can't...
Joni, great book is awesome. We don't have that time to make the bestseller list. We are behind a curve of 2022. It is here. The election issue is here. Our governor race in Maryland is here. Our judicial issues are here. The book is great. I understand it, and you're right. I'm not discounting your idea. But what I'm saying is that we are on the now curve. Not it's coming up and it's soon. We are on the now curve. Everything is about the now. Elect, remove, get rid of. It's now. It's not. 2022 is here.
Right. I agree. I think that maybe a more expeditious solution is in order. But I don't forget that book because you need to generate publicity about these issues, and it must be entrenched in fact and statistics.
I agree. I think
Mary Lynn, please get my Reverend Jones, please get my information out for those attorneys who may be interested in joining in this class action lawsuit. We have to join. I can't do this on my own. I've already traveled that route anyway. But we got to come together if we expect any type of meaningful change. And I hope that those that our community has poured in immensely. I'm talking about us with degrees, money, land, houses, the whole 9 yards, that we have the courage to go forward because this will not change unless we go forward together, unified, to fight this. And my information, if you don't have it, I can share it right now so people can call my law office. But do you want me to share it or do you have it?
Okay, and I'm going to give you a moment to share it in a little while. I just want to address Joni's point, because we can walk and chew gum at the same time. I think this is an issue, like Reverend Jones says, that needs to be attacked at several different levels from several different positions. And so, yeah, we could write a book, we can sue, we could talk to our legislatures, we can educate ourselves so that we could become more aware of the issues. So that way, when we talk to a candidate.
As we are signing off, thank you for listening to Bridges Live. You be the judge. We are here every Wednesday at 6 p.m. You can catch us up later. You can always get the recording. Thank you so much, and we'll catch you next week. You be the judge on Bridges Live.